Just want to signal to put the live stream back on. All right, welcome back, everybody. While we were at lunch, Ashley spent her time doing some research on the order provision, and so I'm going to turn it over to her.
So, just to get started, I want to explain the difference between regulatory and statutory and what in here is regulatory and what is statutory. So if something in our regs is purely regulatory, if we change it during this process, then it's gone. If we change our regs in something statutory, but it's still in the statute, schools would still have to abide by that, and that's what we were discussing earlier. These provisions are purely regulatory. And the reason it's a bit hard to go back and give you all the rationale for it is because the documentation that we have for how far this goes back is from the 1974 Federal Register, which isn't digitized. It's in our libraries here. So this is the first example of where I can find where this comes from. It's this provision right here. To have financial needs, and it applies to FSEOG. I haven't been able to go back and find out when it was added to all of the other programs, but that's the first instance of when we can find where it's existed. So again, we can change it, but if you're looking for, what you've been asking for is the problems that led to this, and because it's so far back, it's a little bit hard to go in there, especially since the preambles for this time period are pretty sparse. So I hope that helps give you guys a little bit of context going into this. Does that make sense?
Yes, Ashley, I think that makes sense. I'm curious as to, once again, I guess the question you can't answer is why that was put in there in 1974, and I guess what was the political landscape, what was happening around that time, what that would incentivize the department to put that language in. So maybe I need to look into that too.
Well, I think the case law has changed pretty dramatically since that time period, and it was probably something that we thought needed to be put in at the time. Relooking at it now, we don't think it is appropriate. Richard.
Yeah, certainly the Establishment Clause law from the time is all still good law. Tilton against Richardson, Pearl against Nyquist, some of the sort of centerpiece Establishment Clause cases that may or may not, I have no idea whether they were what were driving this, but if they were, those remain valid Supreme Court precedent, and so changes on the free exercise side would not affect that. Developments in the law on the free exercise side.
Well, Tilton v. Richardson had nothing to do with this issue. And, you know, the Establishment Clause jurisprudence has changed considerably since the 70s. So I think that was kind of my guess this morning, is that this was left over from a time of a very unusual definition or understanding of establishment that lasted in the 70s, but is no longer what the court is going by. And again, you know, the court's looking at treating, as Trinity Lutheran says, not putting special disabilities on religious people. And if there is, for some reason, a regulation that treats religious people differently, it has to meet a very high standard, which Bill was talking about before lunch. So I do think this is probably a not representative of where the court is, and or has been for a long time now.
I also wanted to mention a couple things about the Department of Justice memo. First, it does talk about the Establishment Clause. It is not intended to eliminate or make changes to the Establishment Clause. The other is that it includes a directive for agencies to do the process we're doing now, to go through and review our regulations. So that is what is driving this more than addressing a problem. I do have a few examples that aren't directly related to our programs, but would illustrate the kinds of things that we're concerned about. One is that there was a social work accreditor that did not want to accredit a social work program at a Catholic college because they wouldn't include abortion in their curriculum. And this is an accreditor that we don't recognize, so it was not one of our programs. But that's the sort of thing that the administration is thinking about. There was also an accreditor who we do recognize who had proposed some changes that we thought would violate the free exercise clause. That was addressed during public comment. They have moved away from that, but that's the sort of thing that we're concerned about. Our general counsel's office also mentioned that FEMA was sued pretty recently over hurricane relief issues, where they were using churches and synagogues to provide relief, but then they couldn't use federal money to build new roofs and things along those lines. They have settled that and changed their policy. So they're concerned about those kinds of issues popping up rather than we don't have a huge number of complaints or issues that we're dealing with, but we want to make sure that we don't have them in the future. We also don't know what the chilling effect is on these regulations. We don't know what institutions might like to apply for funding and have decided not to because they don't meet qualifications. So those are the kinds of things that we're looking to address. Richard?
I guess I wonder if, from what you just said, the department doesn't know who's being affected or how or who cares or is anyone's ox being gored, much less how. And that, to me, raises questions, concerns about both the need for the changes and also the what's being missed. I mean, it seems like the process is recognize a problem that needs to be addressed, look at the data, figure out who is having troubles. If nobody is complaining, maybe nobody's complaining because there isn't a problem, as opposed to things are being chilled that shouldn't be chilled or whatever else. I take it you're saying that the department just doesn't know that, but I would have thought that that was the precursor to regulating, not not something that can just be set aside.
Well, the reason that we are regulating is because the Department of Justice directed us to do this review of our regulations. It was not because we have identified a problem. And we do not have data because we don't think there has been problems. Our religious institutions have been participating in our programs. We are concerned about potential future problems. We're concerned about the kinds of things that I mentioned in these examples, particularly another agency having been sued. We think that we potentially could be as well. So I don't think the data you're looking for exists. I don't think we have data indicating that there were a lot of complaints. This was really more driven by a directive from the Department of Justice. Bill?
So your explanation is what I understood us to be looking at here. But on these particular issues, like the Perkins stuff, the Pell Grants, all of that, I'm also not as familiar with that being an issue. But if we're asked to do in an era of increased sensitivity around these topics, a review about whether or not any of this language runs afoul of potentially some kind of a religious discrimination standard, then I understand why this language strikes me, particularly in light of the context you've given us, is prima facie discriminatory. That's how it strikes me. And so that's why I would support, in the absence of any compelling reason to have it in, it being gone. I don't think it's appropriate for regulations anywhere in the government to be discriminatory in their surface expression. So not without some kind of clear and compelling case that would warrant something like that. Having said that, in other areas, I'm certainly familiar. So I was on a working group for 4 years with APA where we're dealing with APA's response to conscious clause issues. If you're not familiar with that, you mentioned abortion, but this has to do with values-based referrals for mental health professionals and that sort of thing. And our basic position is in APA was to resist supporting conscious clauses for trainees in states simply because the meta skill we need mental health professionals to have that's in the compelling public interest is to be able to work effectively with difference. So often people in the mental health fields are dealing with matters of life and death, and you never know who the client is in front of you despite what the presenting reasons are. If you suddenly had a problem dealing with someone because of a values tension, it could be quite harmful to the public good. And so, but we did put a lot of work into, but how should programs handle that? Taking developmental supportive approach, helping someone find a constructive path forward if they have a value conflict with client, not jumping immediately to a disciplinary posture, which in some recent bad cases have happened by some educators. And then that shaped our accreditation language and how we talked about these things when we revised our standards. And so I've talked to the head of social work about this particular issue, their accrediting body, for instance, and they're coming along, but they're a little less nuanced on these topics. And so we saw the tension of doing a both-and approach. So dealing with religious liberty, identity, diversity issues of the trainees, of clients, but also other kinds of areas of diversity that conflict or collide with that. That's the accreditation interest. We saw ourselves as consistent with our values and mission, also representing professions that become publicly regulated. What would that mean? What kind of responsibilities our trainees would have at the other end of the process. And so that was about a 4-year process of us thinking through a position statement, which now is on APA's website. That's a clear area where those kinds of concerns really do have a momentum of comment, and even in some cases like the Ward case or the Keaton case. But in this particular stuff, my reaction to it is more just the surface appearance of the language and what it conveys if we don't have a good reason for it to be present. So.
Andrew?
Thank you. If you could provide some clarification in your experience with the department and the past negotiated rulemaking processes that you've gone through, how often is it that the catalyst for that is similar to this case where it comes from a Justice Department memo versus something that tend to be more data driven or consumer focused? How common is this versus other types of negotiated rulemaking processes?
So there's a number of different reasons that we would take a negotiated rulemaking on. Now, first and foremost is a statutory change. A lot of our negotiations relate to statutory changes, implementing new statutory language. We also, when there's political changes, people have different views on how we should implement changes in circumstances. There's any number of reasons that we take on a negotiated rulemaking. This is the first one I've been involved in that was because of a Department of Justice memorandum. I would have to go back and see if there were any others, but it's not typical.
That's what I was going to ask. It's not typical. Okay, thank you.
Haven.
So I have 2 administrative questions and a statement. One, is it possible to be emailed that background reference document that you put up? Would love to have that. 2, do we have among all of our current paperwork all the places where this particular block of language shows up elsewhere?
It'll show up in the regulations. Just to give you a little bit of background, the reason this is hard to find is because the Federal Register website only goes back so far. This came from FSA's library of old Federal Register documents, which we've moved a few times, we've lost a few of them, but we ended up contacting FSA, who provided this. I'm happy to send it to everyone. It's public record. It's just not that easy for us to find.
Correct me if I'm wrong. You mentioned that there's maybe 4 or 5 places, I think, Lynn, you said this, where this...
Yes, and those are in
There are.
the
We do
markup
have
that you
those.
have.
Okay,
Yes.
great.
Yeah, I'm sorry if that was confusing. What I was saying was this is the first time I could find the language. We're continuing to search through it. Through
appreciate
the
that
FRs from the
effort.
70s, but this is the first one that we've found so far.
Yeah. And then the last point I'll make is I say this in the light of I would be excited to try to workshop language that does sort of thread the needle between the different points of view in the room. But without any additional background information on kind of how did we arrive here and what was the particular motivations that inform it, there seem to be several potential scenarios that this section governs, which is, I think, why it makes it so complex, because I think that there's a lot that's trying to be resolved in here. I think one potential scenario is an inequitable comparison of assets and income in the sort of EFC process. If you have a student who's showing up saying, I have no money and I earn no money, that might not be very equitable if you can't take into account the whole background financial situation that that particular student, part of a religious order, has. The second issue is where it might bleed into a use issue resulting from the combination of that financial dependence versus or in conjunction with kind of schooling on behalf of that order, being an extension of that order in the process of schooling, or a slightly similar use issue through being actually specifically directed to go get some particular kind of education. So I don't, on the surface, see it as just any religious status or identification is at issue. It's a particular relationship to a religious entity that creates more unique scenarios that run afoul of the use question or a financial EFC equitability issue. So to me, those issues, those potential scenarios still feel, I don't have the documentation or anything to say that those potential scenarios are now immaterial. So to me, it feels like the language should continue to honor what this seems to try to resolve, whatever language we move to.
I guess I'm confused as to how denying financial aid to someone because they're associated with a religious order is not denying financial aid to them because of their religious status, their status as a religious person, which is a direct violation of Trinity Lutheran. I
will do my best. So to me, it does not seem that it is being a part of a religious order, full stop. It is about being a part of a religious order in a particular way in the schooling scenario in which the religious order has particular financial impact and therefore weight in that particular schooling process. So to me, there's a sort of, it's a much more complicated process and scenario that is being described here that has many particular requirements, that is honing in on specific relationships between financial aid, the school, the religious order, and the student.
So, I mean, what a lot of this conversation this morning and just now is showing is why not only do we have a free exercise problem with singling out people who are somehow associated with a religious order, but we also have this entanglement problem, which itself is a violation of the Establishment Clause, when we're starting to have the government try to figure out what exactly is the relationship here, what exactly is the money doing, when the actual question is very simple, is the relationship between the institution and the student, not the student and their relationships with their family, with a socialist commune or a religious order. That doesn't matter from the government's viewpoint. That shouldn't. Now, in the 70s, this idea of we just can't have any interaction between government and religious orders had taken hold for a few years, but it's been so repudiated. And part of the reason it's been repudiated is this Establishment Clause problem in itself. The actual inquiry by the government into all these questions we were just talking about is itself an Establishment Clause violation that's been I can name you some cases where it's just been repudiated by the Supreme Court. So I think that's another reason yet, even if there were any valid reasons back in the 70s to have this, it's yet another reason to delete the language.
I think that might get the entanglement concept upside down in practical effect, because the puzzle is if the government is in a position where it has to make and enforce religious decisions or religious orders, make and enforce, exercise governmental authority. Those are definitionally entanglement problems. The government saying that not that religious people of faith are different, which is not what this says, but saying that the particular financial arrangements of a certain sort that speak to a different conception of need, regardless of regardless of why they come about, that's a different thing. And to try to deal with it categorically so as not to have to delve deeply into individual doctrine and things like that, that's avoiding the entanglement problem. It's not causing one. So I think that's backwards.
Thank you. It seems to me, I mean, the only way to thread that needle, as you were saying, Haven, is if we do come up with new language, if it's completely secular, I mean, no reference at all to any kind of religious order or religious institution, if we're concerned about a disparate relationship between a group that is saying, you go do this, and because of your membership in this group, you're going to give us all of your money, let's say that, with no reference to a religious order, religious group, or anything along those lines.
Stephen, do you have suggestions about how that could be done?
I don't. I think the department's suggested deletion covers that, makes it completely secular.
I think secularizing the language would address the EFC financial equitability comparison issue. If you're a part of an order and they're covering all of your bills, maybe that's not exactly a fair comparison to somebody who's hustling to cover their own bills themselves. But I think it is important to keep the religious question in there, because I think that the first part of point 3, as well as the language of that document you found that sort of seems like source language, that there are some instances in which your membership in that order, you are carrying out religious activity by going to school under their direction and with their support. And I think that that is an issue that still needs to be addressed, because that would be that use issue.
I don't see any problem with the student going to law school because they want to take on Richard's organization's interpretation of these issues as a religious mission, or want to drive psychology out of the mental health business because they think it should only be biblical counseling or something like that. I mean, so I wouldn't like it, but if they go to education anywhere, the purpose of this body is to regulate education and have laws relevant to this. And this particular section is about the funding of it that we're willing to provide to people. It seems like the missing variable here between an establishment issue and what this should be addressing is that it's the student's discretion what they study. Even if it's directed to be a part of a religious order, they can just, as many of my colleagues have in psychology, quit the religious order or do something else. So I think that's what makes it not an establishment issue. I mean, every American citizen can use these things for any qualified educational program. So I don't see why someone shouldn't, just because they're explicitly identified as having a religious interest, goal, or career pathway.
I suppose this, for me, in part gets to, once again, gets to the question what the driving force is here, both about the original language and about the change, because what you just posited is not a free exercise violation. It is, according to Locke against Davey, the Supreme Court's decision there, it is, if anything, in the space between the two clauses. If what you're describing is the right puzzle, it is definitely not something and I'm not sure whether that's exactly the right description, but if it is, then you're talking about in the interstices something where it simply wouldn't be true that this change would be motivated by a need to comply with the free exercise clause, whether Trinity Lutheran or anything else. It would be within the sphere of permissible regulation that the way the Supreme Court put it was to address traditional anti-establishment interests that are designed to protect the religious freedom of everyone, and that and so if the underlying point is this has to be done because it's being driven by the free exercise clause, that just doesn't map on.
So I would like to kind of address what I feel like I've been hearing, and I think from my constituency base, we definitely don't want to discriminate against any student at all. We have students that are of many different faiths, and we support their right to that faith and to operate in such. And if a student has a true financial need, they have a true financial need. And we don't want to say, because you have a certain faith, you can't receive federal financial aid. In my opinion, that's not okay. But as we look at this language, I feel like something that is of concern to most folks, and I could be wrong, would be the simple fact of what is the true financial need. So we talk about the financial relationship. So if they are a part of a religious order that provides them financial assistance, then how does that calculate into their EFC when they are looking at their financial aid award package? And I think that might be a concern, or something really to discuss, or an underlining concern from everyone, is what does that really look like? So not really concerned about the fact that maybe they are a member of a religious order per se, not that that's the concern, but what is that religious order actually offering that student financially to assist them with post-secondary education, and how does that impact their overall financial award package?
I think that would be unworkable from just a standpoint of how would the FAFSA look at that if the purpose is to determine the expected family contribution. I mean, it would require excessive entanglement for the government to say it's not just the expected family contribution, but it's the expected family contribution, and if you have this particular relationship with a religious order, well, that's going to detract from your expected family contribution. That doesn't seem workable to me, but.
So when you mention things like EFC, I just thought I really need to put this in there. That we all know it stands for expected family contribution, but it's not what the family is going to contribute, because that number doesn't change whether it's my local community college or Harvard. You know what I mean? That doesn't matter. It's just your numbers into this equation spits out this result. So that's number one. And two, in the equation, it does take into account, for example, we deal with this a lot, pastors' children who the parent lives in a parsonage where the church provides them housing, and they do have to report that on the FAFSA. So the FAFSA looks at that and says, wait, you're getting $17,000 worth of free housing. We're going to consider that when we say what you can afford, because the normal person that doesn't get that has to cough up that 17 grand. So in the EFC equation, it does take into account the fact that they're getting that housing exception. Now, again, in there, it's generally parents that it's talking about, because not very many of our students, and I say our, I mean just in general, are under that same scenario where they're getting free housing, unless it is one of these orders or anything like that. So I just want you to know the EFC equation does take into account whether or not you're paying those costs as well.
So that actually answered what I was going to ask, is I don't know if the Thank you, sorry. So that addressed my concern to some extent. But even if it doesn't yet, and I think it makes sense that it should, but even if it doesn't yet, as you were saying, I think there's several places where people could get off the book aids, forms of aid or support, and I wouldn't want to single out just religious sources. That's the kind of discriminatory impact. And when I say that, I recognize there's legal language here. I'm talking about this in a straightforward moral sense. I don't, yeah, and the lawyers here can clarify whether or not a technical aspect of entanglement or some other notion might apply. But I think that unless there is a specific, unique problem arising from religion that we're trying to address here, I don't think we should single that out in our discourse.
It's been a while since I've done any financial aid documents.
Good for you.
But I absolutely take your word on it that it sounds like there are mechanisms to address the equitability issue in assessing the whole financial picture of a student, whether they have backing of a religious order or not, which would then point the sort of financial question toward that financial arrangement or that financial relationship constituting or drawing a picture of that pursuit of education within the student as part of a religious activity and therefore a use issue and not a financial equitability issue.
I want to be careful not to, talk about case law too much, but given we have regulations and then we have the statute, but then we have the Constitution, the case law is relevant because the Supreme Court's told us what the Constitution in this area means. And so knowing that language that you had up earlier from 1974, that was very helpful to position this issue, because it was in 1979 that the Supreme Court had a case before it where Tennessee had this idea that it had had for 100 or more years, that it would not allow ministers to serve in the state legislature, McDaniel v. Patty. And the Supreme Court said, well, that's discriminating against people because of their status as religious people, and it's a special disability. So my guess is, this is 5 years after the language that we were looking at that is the origin of this language. And it's that whole lot, you see kind of that shift starting with 1979 McDaniel v. Patty, the idea that even ministers can't be singled out for discriminatory treatment under the Establishment Clause of the federal Constitution. And then that decision is very much at the heart of, and it's cited numerous times in Trinity Lutheran. So going to Richard's earlier point, that case and others are the basis of the idea that if on its face a regulation or a statute disadvantages religious institutions or religious people, then the government has to come in with a really compelling interest. It can't just be, it can't be just a good reason. It has to be a very specific and very important reason for singling out religious people for discriminatory treatment.
So I wanted to let folks know about something that I'm finding pretty helpful, which is from the Federal Register in 1992. I'll give you a site, but then I'll tell you what it is. It's 57 Federal Register 60304 and 60305. These are in response to comments on, it happened to be 682-301, entitled Eligibility of Borrowers for Interest Benefits on Stafford Loans, but I believe that that's the same, that's the parallel provision. And what the department says at the
I'm
time...
sorry, Richard, can I interrupt you for a second?
Yeah.
If you give me, if I can come over for a second and get the citation, I can try and throw this up on the page.
Sure.
Yeah, so everyone can see it while we talk
All
about
right.
it.
It is 57 Federal
Okay.
Register 60304 and 60305. Yeah. And so you'll be able to see it, but what it says is the Secretary is clarifying the regulations. They're not intended to apply to every applicant that responds to a question on religious affiliation. In other words, they're not about saying you have a religious affiliation, so you're out of the program. In determining an applicant's eligibility for interest benefits, which happens to be, as I said, this particular section where the comment is, if the school has received information indicating that the applicant is a member of a religious order, group, community, society, agency, or other similar organization, it's required to document whether the conditions entailed in the subsection apply to the applicant, because here's the important thing. In the Secretary's view, service in such an order generally reflects that the individual is supported fully by the order. If it meets those criteria, it's saying, then it generally it reflects that the individual is supported fully by the order and does not have financial need for FFEL purposes. A school is not expected to make a determination unless it has reason to know that an applicant is a member of such order and meets the criteria in the subsection of the regulation, and then the school has to document that. So what the Secretary explained was this is all about figuring out whether there's really need or not, given that certain relationships for certain applicants with their orders will mean that they just don't have need. That's not religious discrimination at all. It's a category mistake to use that language. That is really about figuring out whether there's need, understanding the relationship, and that's what the Secretary described as the aim here.
That is helpful, but this is a chicken or the egg thing. I would love to have the original language. That would be very helpful, because if not, that sounds to me like a post hoc attempt to position it in a constructive way, the language. That's what it sounds like to me, but that's entire speculation, so I have no idea. I'm not saying what you said, I'm saying what was written and what you cited.
It looks like we're past the point where the online archives of the Federal Register ends, but I can try and pull that later for you and for everyone if that's helpful.
And I unfortunately am just looking at a snippet, just the pertinent part of the section, and am not sufficiently technically savvy to know how to get it there to you. If I were younger, that would be easy, I'm sure.
So we've had a lot of discussion around this provision, and I think it's been really helpful, and it's kind of gone to the core issues, and some of these issues are going to arise again in future language. I'm wondering if people feel like it is worth it to try to create language that everybody is comfortable with, or if it is better to go forward with multiple options to the full committee. Manuel.
So I, of course, can only speak for me and my constituency, but I know that we would not want to discriminate against any student. And I think that no one at the table would, but as it relates to a proposal, if we are still, we took a temperature check before we left for lunch, and if that still remains true, and some people believe that this is definitely what we should do, and then there's others that believe something differently, and it's split kind of like it was, then that would seem to me to the outcome would be two proposals to do two different things. So, but from what I had said earlier about the financial part, I know that on the FAFSA, and I'm just mentioning this, is students are able to indicate what other aid that they have received. Well, the question actually says money received or paid on your behalf, such as bills, but then that could mean bills and other things, not reported elsewhere on this form. This includes money that you received from a parent or other person whose financial information is not reported on this form and that is not part of a legal child support agreement. To me, that sounds like that's a section where, you know, it's the onus is on the student, but they could say, oh, yeah, I did actually receive X, Y, and Z from this organization or this other person, or, you know, there are additional resources, but, you know, how do you follow up and make sure that's the case? That's another question. I'm just highlighting that there is a question on the FAFSA that does ask for additional financial assistance other than them doing the IRS data retrieval tool to actually determine their EFC and what that would look like.
Greg?
Manuel, thank you for bringing that up, because I have to instruct people all the time to watch for that question, because it is imperative, because the EFC does take it into account differently. Grandma gave me $1,000 for my schooling. No, that's not going to show up on a tax form, so it's not going to show up on the data retrieval. It's not going to show up anywhere, but it is money that the kid next to me didn't get. You know what I mean? So it does show up in that purposes. And the EFC treats it differently than it does $1,000 in income, because the $1,000 in income from your job at Walmart, they know that you got taxed on it, so they take all that part out and they say this is what you end up with. And then when they figure out how much money you have for school, they take into account how much of that is normal everyday bills, how much do you need to live, and then how much can go towards school. So they do take it into account, and they do kind of look at it a little different than earned income, because we always just use the phrase untaxed income when we're talking about that type of income on the FAFSA. So it's a very good point.
Greg, if you could clarify, so in that particular question, where does in-kind types of services that somebody might receive, housing, food assistance, non-cat, how does that get quantified in that?
Sure. In-kind housing generally doesn't, because you can't cash it out. You can't. If grandma gives you that $1,000, you can take it and do whatever you want with it. If she lets you sleep on her couch, you can't sell that. It doesn't have a monetary value. So in kind, the way we've always understood it to mean is that they're giving you something that you can't turn around. It doesn't have a cash value to you. So you don't put on there, grandma let me sleep on her couch, and that was worth $1,200 a month rent. You know, I mean, you don't have to quantify that kind of stuff.
Anne Marie, do you want to?
So I painstakingly went to my phone and jotted down the same information that Emmanuel had just read to you. But there's also in that same grouping another one related to untaxed income. The question about in-kind, the way the department looks at in-kind would be from generally someone like a relative that's providing food. But we also have a question on the FAFSA that says housing, food, and other living allowances paid to members of the military, clergy, and others, including cash payments and cash value of benefits. So if it was something like clergy was getting a housing allowance or housing provided to them, they would be expected to put the value of that in that area. And again, as Gregory had mentioned, it is treated differently than traditional income from work. The FAFSA does not take out those other income exclusions that you would have on income earned from work, because the idea is that you're not really receiving all of that to then possibly spend on the other necessities of life. But there are multiple places that the student and or in some cases the parents would need to put these kinds of things and list them out. And then that gets, it's part of the equation that we use to determine that need.
Bill.
That's very helpful. So I was thinking of our two options here. Do we go with two proposals? Do we do one? I don't know if this would be adequate for those folks who don't feel comfortable just deleting what is going with what the Ed Department is recommending here. But even if we did find sufficient rationale to accept and support this deletion, could we offer recommendations that they tighten up guidance around these kinds of financial aid forms to make sure those issues aren't glossed over it? I like the way that seemed to be worded, that it wasn't religion only, but they were looking at where this kind of benefit could come from multiple sources. However, I do see some relevance when we get to things like deferment of repayment. So for instance, if you think about criteria for a hardship deferment, if someone's choosing to be in order where they're taking a vow of poverty, whether it's religious or anything else, and so they never can have enough money to not be qualifying for a hardship deferment until they max that out in length of time, that does seem to me like it's sort of contrary to the interest or the purpose of granting that. So I don't know, that's way in the weeds, I know, but it seems like there might be a relevant thing here with something like that. But apart from a case where it's really relevant to the purpose or language, I would recommend we tighten up guidance where this might be covered through existing procedures like our financial aid applications.
And we certainly can recommend tightening up guidance. That would not be part of a regulatory package, so it wouldn't be part of a consensus vote, but it is certainly excellent feedback for the department, and we can take it back and work on that a separate track.
Thanks. From the Gear Up community that I'm representing, I would want to caution the committee around unintended consequences. There are many efforts right now for FAFSA simplification, and Gear Up students in particular are the ones that are most poised to benefit from a FAFSA system that needs to be simplified. And so I'd be concerned about the unintended consequences of trying to create additional guidance for the purpose of ameliorating this issue when it would just be potentially kicking the can down the road for a FAFSA system that we're getting close, but needs to be overhauled. And I don't want to move in that. I want to move in the opposite direction, not in the direction that you laid out. But I appreciate your idea, though.
Okay, so I maybe I'm being optimistic, but I think that we could have one recommendation potentially if the true concern is regarding the financial need. If the true concern is not whether or not they are a member of a religious order, but just it's a student who wants to go to college and they need some help. But how do we determine how much help that is? If that's the true concern, then I think that there's a path forward for us to have one recommendation, if that is the true concern. But if that's not, if them being a part of a religious order is a concern for some at the table, then I think that would determine whether or not it's one or two. But from what I'm hearing, it sounds like just the financial need aspect. What is your true need? What does that look like? May be the crux of the issue.
I'm wondering whether there wouldn't be value to bracketing this issue for the moment so that people can, think about it overnight, do some homework, and then come back to it tomorrow to see if something like you have in mind or whatever would work. I know that there are some things that I will want to look up and spend some time with. Maybe others will as well.
That sounds like a good idea. So we will table this for now, and there is another provision in the Perkins section. Why don't we tackle that? And then it might be easiest to then do Pell, which is probably the most straightforward. Get some of it. Okay. So the next provision in and Perkins relates to deferments of student loans, and we're going to see this language again with other loan programs. Basically, there's an opportunity to defer your loans if you are a full-time volunteer. There is currently an exclusion in that language if the borrower, as part of his or her duties, does not give religious, I'm sorry, I did the lead-in wrong. So the borrower need not repay principal and interest does not, and interest does not accrue for any period not to exceed 3 years during which the borrower is, and the exclusion is, the borrower is a full-time volunteer. And then the secretary considers a borrower that's providing comparable service if he satisfies the following 4 criteria. One of them is the borrower, as part of his or her duties, does not give religious instruction, conduct worship service, engage in religious proselytizing, or engage in fundraising to support religious issues. There's multiple versions of this in the Perkins loan program because of the dates the loans are made, but it's the same language in both cases. Same deferment, it's just which loans they apply to. So any discussion on that provision?
Just from a procedural, Ashley, is it possible for you to bring up what what we have here is just the one criteria that's proposed to being deleted? It would be useful to have the existing 5 criteria just to have the appropriate level of context. Yeah, sure. Thank you.
So that was part of it, so that would be very helpful. Do we have, it sounds like, is there a listing somewhere of programs that the Secretary's already kind of decided are acceptable? I mean, do we have a list of these are the safe ones? And so there's a couple listed here, but I'm wondering, am I reading that wrong, or is there?
No, there are 2 listed in the reg, but it's basically any programs that meet the criteria. We don't have a list of acceptable programs.
So the interesting thing to me, if that's the case, would be whether or not we've accepted for this purpose entities that are private mission kinds of things that are not government bodies, or I guess I would be interested in that, just to know how I would think about that. I don't know if it's clear why I'm thinking that, but
You got it.
Yeah. Okay, thank you.
I'm happy to state for the record that I, as a Peace Corps volunteer, very much appreciated the Perkins loan deferment and Stafford loan deferment that I had. So this one's personal for me.
Can I ask where you served? I'm also an RPCV.
I was in Hungary in the 90s.
Nice.
And you?
Kazakhstan.
Okay.
2008 to 2010.
Let's talk.
Yeah.
Air Force.
And this won't take long. And when we, in general conversation with students and families, we've always referred to this in a colloquial kind of this is a way for the government to kind of just pause all of this stuff, let you go do this service to humanity, whether it's through Peace Corps or, almost, we've heard of countries that require high school graduates to then stop and go do this and this and this. And this is a chance to allow folks to be able that have that service attitude in their heart to be able to go do something good for mankind or person kind, and kind of pause the button on, you having to suffer financially because you chose to do this. So we think it's a neat idea that they do allow them to pause that like that.
It seems to me that this provision here is one that we can't look at in isolation, not just because it shows up in the other parts in the Perkins, but it's all a part of the issue that we see winding through so many of the proposed changes from the department that really get to what the government is paying for or not paying for, and are religious activities deemed public services or not. And I think that we probably need to have that conversation at that level, whether that is the right or the wrong way to think about things, rather than looking at just from sort of luck of the draw that we're starting with this provision here as opposed to the same thing everywhere else that it shows up.
So for me, what I'm 1 through 4 are pretty straightforward. I want to also clarify in case people, when you look at 1 through 4, you'll notice that being a national service through AmeriCorps or being a VISTA does actually not qualify for a deferment. If you are an AmeriCorps member, if you're doing national domestic service, you only get a forbearance. So it costs more to be an AmeriCorps member than it does to be a Peace Corps member. So I think that's important context to keep in mind. But what I'm curious to know is if the department has, what historically has the Secretary determined to be comparable service historically in number 5, and I think that is in order to do an apples to apples comparison, we need to know what has been the past precedent for 5 in order to fairly look at what's being proposed here.
I just wanted to ask Andrew for clarification because I didn't quite understand why we needed more context. I'm sorry, just if you
No,
could
I think
explain
it's
again.
important that there is, the way I see it and from the constituencies that I represent, there currently already is a lack of parity in terms of how the department handles a certain national service participation. And so I'd be uneasy about providing a provision for something that's based on the Secretary's determination, while the fact that one of the largest national service programs that we have doesn't enjoy the luxury of this provision.
If no one minds, I'm going to check this cross-reference here to see if we can answer that question now.
I look up at the screen and I don't know who put it first, so I'm not trying to have them jump the line, but I saw Bill's first.
So that would be very helpful to me too. I don't feel really comfortable with the disqualifying part of it being that you do some religious instruction or help with worship. It seems to me like the nature of the service should be, so certainly if that's all you're doing, if all you're doing is religious activity, but there could be jobs programs, or it seems to me lots of things that are secular goods, but the cited things in the language here, those of you who are more, particularly our Peace Corps volunteers and others, are those all government initiated service activity and supported programs? Or do they have a life of their own separate from a government identity?
I can answer that question. So every program that I did, every school that I worked with, every NGO that I supported and worked with was part of a work plan that had to be approved by the Peace Corps. So there is a certain level of accountability that comes with being a Peace Corps volunteer in setting up the scope, even in interest in secondary projects. So in my particular case, I was a environmental education volunteer. I wanted to volunteer, sounds silly, but volunteer while I was a Peace Corps volunteer to go work at a Bosnian refugee camp, and that had to go through particular protocols within the Peace Corps, even if it was during my own free time, even if it was on weekends, even when I was when I was quote unquote off the clock, while I was with the Peace Corps, I was representing the United States Peace Corps, and so therefore there was a high bar of accountability.
Yeah, two things, I guess. One is that Andrew's drawing our attention to something that I didn't know, that AmeriCorps and Vista are don't get the same status. Is particularly interesting and strikes me as important because it sets the terms of, I mean, I think on the face of it, thinking categorically about this kind of a provision as it shows up in all the places that we're talking about, so that we might be talking about deferrals, we might be talking about public service grants, we might be talking about all those different things. We're talking about ways that the government is funding the service that is provided. That, number one, speaks directly to the constitutional concern about the government funding religious programming, funding, to use the language from, this particular instantiation of it, religious proselytizing, conducting worship services, fundraising to support religious activities. Those are things that the government categorically isn't supposed to be funding. And it is particularly interesting to me, too, that I think that one can't, to get back to something in our earlier conversation, one can't say that this is exclusionary in ways that are treating religion differently, when in fact this is treating, to get rid of this provision and to allow the funding to be used in this way would interestingly be treating religious service not just as public service, even though it's serving my church or synagogue, not the public, which is a serious difference, but also that it's treating it better than we treat AmeriCorps and Vista folks and stuff like that. And that, to me, is an odd and ill-fated policy, as well as one with real constitutional concerns.
Has a response to the AmeriCorps.
Again, I'm not an expert on AmeriCorps by any means, but the way I read these regs right here is when you see one of the accepted deferments, volunteer under the Domestic Volunteer Service Act. When you jump to that, it does, at least at first glance, appear to include the VISTA programs, which I believe are part of AmeriCorps. Again, that's something we could check with them, but
yeah. That's a helpful clarification. Yeah. It's possible that VISTA may be covered, but certainly AmeriCorps.
I thought Vista was part of AmeriCorps, but I might be. Another under CNCS.
We should look, because it's clear, I'm sure, that you can find that AmeriCorps, I mean, I've run AmeriCorps programs. They only qualify, the volunteers only qualify for a forbearance.
Okay.
And so therefore there is there's a cost benefit. It costs money to be an AmeriCorps member from an interest perspective, as opposed to being in the Peace Corps.
I would just say again, this is a federal benefit available to an individual person. While Congress can give the Secretary discretion to make certain choices about where that can and can't go, what Congress cannot give to the Secretary from an authority standpoint is the ability to discriminate on the basis of religion. So there is that conflict between the Establishment Clause and Free Exercise Clause, and to have that language in there, I don't think it's so much, in the terms of unintended consequences, I don't think it so much allows the government to participate in proselytizing. I think it hamstrings the nursing student that might want to go to Zambia and participate in a humanitarian mission, who also is participating in worship services there with the church-run nursing center. So I think it's beyond the Secretary's power to not allow this government benefit to an individual because of that.
So it certainly makes sense to me that we don't want a provision that lets someone defer student loan or repayments interest-free just to go do a religious mission. That seems like it's clearly inappropriate. In my view, I don't know that there's an accreditation interest here specifically, although I think there's a lot of people probably at accrediting bodies that have interest about these things. I also don't see any issue with us saying some things we're going to allow this to apply for and not others. It seems to me like that government does that all the time. There's certain things they want to incentivize, and it does seem rather strange to me if the Ed Department, no offense, gets to make that decision. That seems to me like, I'm wondering if there was a congressional request or something that said, please put this in your deferment, kitty, something like that. I wonder if there was something like that, how that comes about. So, but it does seem rather strange that the Ed Department would be deciding which public goods we're going to incentivize in this way and which ones we're not. But that's beyond the scope of, I think, our focus here. Except it could be potential, right? It could be potentially be relevant to our scope if there were things that had private missions that were not government supported that they were giving this to, but we're not giving it to religious groups that are doing public goods, job programs, homelessness programs, exit programs for people coming out of incarceration. We can think of lots of them, I guess, but
So just looking at this is exactly the situation that Trinity Lutheran Church faced in that case, because there was a list of criteria for there. It was actually government giving money. Here it's just the government's allowing some deferment, if I understand how this works. It's not actually any money going to the person. And so it's actually even less than what was happening in Trinity Lutheran. But basically in Trinity Lutheran, the court's saying there's a list of criteria, and one of the criteria is you can't do religious stuff. You can't be a church, or here you can't engage in what is really religious speech, and it's free exercise, if not just speech. So I think this is exactly the situation that the Department of Justice would anticipate needs to come out. Just because of that, I mean, we're really not supposed to be focusing on the rest of it. Just that one provision is actually saying you qualify to the individual except if your speech is religious. That's what that whole list is about. And under all kinds of cases besides Trinity Lutheran, Rosenberger and Widmar, you can't penalize people because their speech is religious.
I just want to make one clarification. For deferments, interest does not accrue on the loan during the deferment period, unlike forbearances where interest continues to accrue, but the participant doesn't need to make payments during a forbearance period.
Thank you. I just wanted to clarify for that. That would be for the subsidized Stafford program, not for an unsubsidized program. So for direct loans, there's a distinction, and depending on the type of loan they have, it may be less of a benefit depending on the type.
That's correct. I just did want to say that in some cases there is a benefit.
But just so I understand, I mean, we're still just talking about a government program of benefits that are available to everyone who meets these criteria. Is that? That's right.
Correct.
Could I add that when you say that there's really not a cost factor involved, the cost, if you want to say it here, is lost interest for the taxpayer. Do you know what I mean? There is a cost in deferring instead of forbearance, there's a cost of lost revenue to the government of the interest part of it, but it's minimal compared to what you're probably thinking.
Yeah, I think what I'm trying to say is that's a cost that the government incurs regardless of whether an individual is engaged in is doing something with, say, a religious soup kitchen as opposed to a non-religious soup kitchen, right? It's the same cost. And so that becomes a generally applicable benefits program that you can't exclude people from just because their speech is religious.
Yeah, I just don't think that that's a correct description, because what this provision says, it doesn't talk about or doesn't make any determinations based on whether you're a person of faith or what your beliefs are or your affiliations or anything else. What it says is we, the government, will, whether it's give a deferment or give a public service grant or whatever else, we, the government, will spend money to support certain conduct that is treated as public service. And public service is defined to be things like the Peace Corps, and to say what we don't pay for is we don't make expenditures to fund Richard going on a religious mission. We don't fund for Richard to be proselytizing or to be conducting religious services or anything else. That's not only a choice that the government can make that has nothing to do with the sort of discrimination box that you're trying to put it into, but it's something that's a rule that's required so that the government isn't funding religion. It's not treating all people equally, because this isn't a general program that everybody in the world gets free money from the government for school. It's not free college education. It is if you're doing certain sorts of conduct that are public service that we want to create incentives for, then you can get money knocked off your loans in one way or another. And that, for the government to say public service is public service, and raising funds for my church isn't public service, it might be a noble cause, but that it's not public service, that those are really just different things, and to try to treat them together just categorically doesn't make sense either doctrinally or practically.
Well, I think we don't even have to look to Trinity Lutheran, although I think that, for the reasons I just laid out, does control here. But also, the argument is, not just the argument, but in Rosenberger versus University of Virginia from 1995, so it's 24-year-old opinion now, the Supreme Court ruled that the university could not refuse to fund a student publication that proselytized and was very evangelical and religious in its viewpoints if the university chose to fund other student publications. It's called viewpoint discrimination. It's a violation of the Free Speech Clause, and you can't discriminate against religious speech. So that's the real case that would say that this provision is unconstitutional. And it's not that the government is funding religious activity. It's just that the government is remaining neutral as to the choices that the individuals make. So the government isn't funding someone to go work at this, soup kitchen or that soup kitchen. The government is just simply saying, if you want to make that choice, we'll make it a little easier. But the government can't say, we'll make it easier for people who want to do this for a secular soup kitchen, but not for people who want to do this for a religious soup kitchen. That's where it becomes discrimination.
I think the distinction here, though, is that until we get the list of programs that the Secretary has determined, everything else falls into a pretty unified bucket of participation in some sort of federally appropriated service. And so I think we're minimizing what it means to be a member of the armed forces, a Peace Corps volunteer, or a volunteer under the Domestic Volunteer Service Act of 1973 by I shouldn't have said arbitrary, by grouping them all together. I'm also curious to know if the department has any fiscal note associated with what the cost would be to implement, to remove this provision, because I do know that, all the other things, being in the armed forces, being in the Peace Corps, those are appropriations and there are allocations. They know how many Peace Corps members there are. They know how many people are going to be in the military, so they can make formulas about how many people are likely to take that. I'm curious to know what the financial ramifications would be of this.
So I probably should have said this earlier in the introduction, but the full committee will vote on consensus language. If they receive consensus, that's what we publish in a notice of proposed rulemaking that goes out for public comment. As part of the notice of proposed rulemaking, we need to do cost estimates and cost-benefit analysis. And at that time, the department would run the costs of various proposals. We don't have that information now, and while cost is certainly an important thing, that really shouldn't be part of our deliberation. We would work with OMB on the cost estimate. Thank you.
As we talk through this, I'm interested in the examples we're citing. So if you have a religious contextualized thing that provides services that most people would recognize, I think, as a common good, versus sending someone off to build another branch of your congregation, and so that it seems to me like it's hard to make those distinctions, and this is beyond me whether or not the government would even ever want to try to make those distinctions. But this phrase that starts off a full-time volunteer in service, before we move into the rest, in which the secretary has determined it to be comparable service to these other areas, it sounds like that's implicitly assuming some kind of notion of public good that it's wanting to incentivize in a selective way. And that, I imagine, would lead to all kinds of interesting seminars in our philosophy program debating about what the public good is and how we know it. But I think if we see those list of examples, and there really were ones that stood out that were clearly particular service context that would not be widely recognized as a sort of government established service entity, that could be more problematic than in ruling out religion, but for maybe similar reasons to what you were saying with the viewpoint discrimination. I don't know. But I certainly don't think the intent here should be to fund people not having to pay back their student loans so they can go establish another branch of whatever religion they're in. So it seems to me that by itself is, if anything's meant to be barred by the Establishment Clause, it seems like that falls under the scope of it. But now I'm starting to talk legally, so I'll stop because I don't know.
And the Establishment Clause continues to apply.
So I'll just pick up with the Establishment Clause. So going back to the Rosenberger decision, for reasons we talked about a little earlier, and you were just starting to get into, when you start having the government make a decision as to what's religious and what's secular, that in itself becomes an Establishment Clause violation. And so that was part of the Rosenberger rationale as well. So it's not just that we're trying to protect free speech and free exercise, but we're also avoiding an Establishment Clause problem. And I just wanted to be clear, I mean, the regulation is talking in terms of the Secretary determining that it's comparable to service in the Peace Corps or the Domestic Volunteer Service Act. But what's really determinative are the 5 criteria. And those are quite broad. So it would be interesting to see the list of what this applies to, but it applies basically to a tax-exempt organization that it helps people who are in special need and who are paid not very much, and they've agreed to serve there for a year. And the only thing that disqualifies you is this engagement in religious speech, which is just what the problem is. So I think it's not that the government is setting up particular government programs. It's just the government is saying, if you do this in the private sector or the public sector, we'll allow you to defer. But the disqualifier is being engaged in religious speech, which is a problem under a number of Supreme Court precedent.
So I think there are a couple of things wrong with that analysis. One of them is Kim, you started with the assumption that this is a general benefit, and it isn't. It's not a general benefit program. It's not anybody is entitled to it. It's you perform certain sorts of services, you're entitled. So that's categorically different to begin with. And then to take Rosenberger and to try to describe that as if the government funds anything, it must fund people proselytizing, fundraising to support religious activities, conducting worship services. That has nothing to do with a restriction on speech. And what that is about is the government not paying for religious services, religious proselytizing conduct that the government isn't supposed to be in the business of sponsoring, because when it does, it ends up picking and choosing and sponsoring some things rather than others. It ends up involved in religious favoritism that is categorically barred, because that's not how we respect the faiths and the belief and the religious practice of everyone. And so I think you're sort of trying to transport doctrine that just has no bearing into a context where this is just about, is the government not in a general program, but in a particular thing about public service? Is the government buying the provision of religious services, or is it buying soup kitchens? And the government does get to make those choices. It does it all the time. That's what the whole point of the faith-based initiative is about, is to say there's a categorical difference between religiously affiliated or religious entities performing social services, performing public services, and the provision of religious services, the former of which we can fund and the latter of which we categorically can't fund.
I just to pick up on what Richard said, I want to make sure that as we talk about this, that we're not blurring the word speech and duties. So it does say here the borrower as part of his or her duties, and so I would caution us to blur the word speech and duties, because I don't believe they're one and the same.
I am also excited to see the list of existing things that have qualified, because this itemization seems very specific about, it's not just from the jump, oh, you wanted to go work at a religious organization, then no, you're out of luck, but really it itemizes very specific duties undertaken in pursuit of proselytizing one particular religious worldview, and that seems material. I'm curious. I mean, is there a religious organization somebody could have worked at and qualified because their jobs didn't have anything to do about carrying out specific proselytizing or instructional activities? I'd love to vet that.
So I just wanted to respond to Richard's point about the general benefit program. I think it's clear that deferment on student loans is a benefit, general benefit program. I've talked to enough college students or recent college grads to know it's a benefit, and it's generally open to anyone who has these loans. So I don't know how this cannot be a general benefit program. And all of these categories, religious instruction and religious worship, of course, are the exact speech that have been involved in a number of Supreme Court cases, including Widmar be the prime example, but Rosenberger. Religious proselytizing is just another word for speech. And of course, we know from all kinds of free speech cases that the ability to fundraise to support a cause is very basic speech. You know, this goes back to for early speech cases of the 1940s, and they often involved religious speech. So I'll just stand by the fact that I think this is unconstitutional under a number of Supreme Court cases, not just Trinity Lutheran.
Sorry, I was going back and forth because something about what you said about AmeriCorps forbearance just rung a bell, and I wanted to go back and check this out. For our purposes here, just so that we all know, it may be academic to whether or not I'll go and confirm either way as to whether they're eligible for a deferment, because it looks like CNCS pays some of the interest that accrues during a forbearance. Some are part of it, and so that might be why it hasn't gotten all the quite as much attention in our regs, because the CNCS looks like they take care of that. So you're right, it's forbearance, but they pay for the interest costs.
So that suggests to me that there was some logic in considering what they use as examples and not that they explicitly listed. What I feel uncomfortable with is not the saying, look, this can't be used just for, and I get the tension around the government being in this business of deciding what's religious or not, but just for launching your new church or something. But if someone is doing a public service agency that's providing a free medical clinic or something else, and they want to consider this an equivalent kind of service, if they're doing the full amount of the public service we would want anyone to be doing this, then they're staying afterwards and having a Bible study at night, it seems kind of weird to me that would be disqualified on that basis. So I would consider the government's interest there in the public service being provided. But if it's a selective list like this of government initiated or supported service programs that are limited, specifically targeted for certain purposes, and we don't have that other, then it would be a game changer for me and how I think about this. So, of those equivalent kind of things that have been approved.
I would just say in response, it's my interpretation that it is a part of his or her duties, not a choice outside of his or her duties, but literally a part of the duties of the assignment of public service to do the things that are listed. And if they don't do those things, then they're not meeting the requirements, which in my opinion is two different things.
That's a good point. And Haven, to your point, I agree that there is a distinction. There could be people who, my son went and worked at Mother Teresa's Institute for the Deaf and Dying. And so what my son did had nothing to do with anything religious. It was cleaning up when they urinated in the bed they were laying in as they're dying. You know what I mean? And there are human factors that they can do in their job. The job description had nothing to do with anything to do with religion. And so they're, you know, in his case, and in most of their cases, they're there to do a job to serve humanity, not necessarily anything to do with any kind of, so I think you're right, there could be differences of positions in what we say their job duties and requirements are. Does that make sense?
Yeah. I have an intellectual curiosity down that stream, and so I want to know, like, has that situation arisen? I imagine has, and what was the result? Though, speaking on behalf of my constituency of LGBTQI people, if there were, jobs paid for, duties paid for, and funded to work at a religious institution that is not accepting of and willing to provide services to LGBTQI people, my constituency would not consider that a public good. So I add that to the mix.
I wanted just to respond to Greg, but I appreciate the example that you brought up, and the work sounds important and amazing. But the slippery slope there is what you just described. Oh, you just took it off. That's okay. What you just described, I'm not sure meets the letter or the spirit of service to low-income persons to assist them in eliminating poverty, human-related condition. Not to say that the work that isn't important, but the reason and the reason why I say that is that's where the slippery slope becomes of what the work that's important versus the work that is intended to meet the both the letter and the spirit of the provision.
Yeah, the provision 4, again, focusing in on the word duties. Just looking at the thing as a whole, the Secretary is assuming for herself in this regulation the ability to pick and choose which service is comparable. She's not able to make the choice that it can have any part of the duties can be related to proselytizing, religious instruction, conducting worship services, etc. To really know that, it sure seems like the Secretary would need to see a copy of the duties, and just to assess that, I'm not sure constitutionally that's a question the Secretary can ask and avoid an excessive entanglement in religion to figure out, is this the kind of religious thing that might pass or might not? And that I think is, it's very difficult for something with the word religion in it to pass the facial neutrality that's required.
How difficult will it be for the department to provide us with the list of organizations that have been provided this provision?
We'll try and dig that up for you. I guess the answer right now is I don't know.
So there are all kinds of requirements throughout, whether by statute or by regulation, about the government not funding explicitly religious activities. I think that's well settled and well understood, and I'm not sure that I'm sensitive to the problem that you're wrestling with, but I think it's something that the government does all the time, and there are settled understandings and definitions, and that in practice that actually doesn't present the problem that I think you're worried about.
So it's now 3:04. I had promised a 3:30 break, but I'm getting the sense that people may need a few minutes. Would it make sense to break now for 20 minutes? And thank you. So it's 3:04. Let's come back at 3:25. You can have 21 minutes. Thank you. Welcome back, everybody. We are missing two, but I understand one had to be on a call. We can go ahead. So we have discussed almost all of the language, not in the context of each individual program, but there's two places where there's language we haven't discussed, one in work study and a couple places in the Gear Up program. So we thought we'd start with those so that you can take that back and think about it this evening. And so the first one is on page 2 under Federal Work Study, and Ashley's going to walk you through it. So on the red line document, page 2, Work Study, which is part 675, and 675.20, the last line of that is
It's highlighted up here too. Okay, so when I talked a little bit earlier, I talked about the difference between purely regulatory and then statutory language as well. This is a bit different because while this language isn't strictly statutory, the concept is. I think it might be helpful to also look at the statutory language around work study. So generally the idea is that federal work study employees aren't, cannot be paid to operate, construct, or maintain a part of a facility that's used for religious worship or sectarian instruction. That does come from statute, and it's right here. So we're in section 443 of the HEA. And then it's a little bit of a page break, so I'm sorry about this, but you can see, yeah, grants for work study programs. So that is one of the prohibited activities, but as you can see, the statutory and the regulatory language are a little bit different. So I'm curious to see how you all would like to handle that.
I would initially say I always believe that it's important to follow the statute and, of course, understand congressional intent. And so this language here in the HEA, it says does not involve the construction, operation, or maintenance of so much of any facility. And so the proposed change is the part of a facility versus any. So I think what we're talking about really is the word any facility, and what does that mean versus any part of a facility or the part, because those are two different things, because that's saying facility as a whole, as is used or is to be used for sectarian instruction. So
You can see why we may have streamlined that.
This is one of those situations where it strikes me as surprising to switch from, when the statute uses any, to switch to the, and I wonder what was intended to be the change there. What does the department understand to be the consequence of that change?
There was a thought that the was more clear than any. I'm not sure that it is. We could go back to the statutory language, which might be the more clear thing to do. I think we would be open to how to define this concept. We're not wedded to particular words.
Could you just go back to the, and what section, 42 USC?
Yeah, it's maybe in section 443. Here we go. 440. Yeah, the full citation's up here.
Okay, great.
Yep. Or.
Mm-hmm.
Can you just go back to the highlighted bit?
Sure.
Thank you. If folks are ready for that.
So back to a point that I made earlier, and it might not really be that clear to you, but what I was saying earlier about our student workers who clean the lobby and the restrooms and everything of this building is not the same as if I see any part, or the part of the facility used. In other words, that's different than straightening the hymnals on the chairs of the inside the chapel and that kind of stuff. If I read the word "the" portion of the facility that is used for worship, would that make sense? In other words, if we did change it to "the,"
I'm not sure I
that's okay.
followed.
So if we change it to the part of the facility used for worship, are you saying, do you think that would imply that we could use student workers to clean the lobby and the outside and the restrooms and all of that? Because even though it's a part of the building, it's not the part that's used for, is that splitting hairs, or do you think that makes sense?
I'm interested in what other people think the language means.
Okay.
Well,
Yeah, I'll take a first shot. I mean, I think this is clearer than the statutory language because of what Greg's kind of identifying. But I don't think it's a change from the statutory language. I just think it's clarification.
and do you think that the is, which is more clear, the or any, in the regulatory language?
I think the is more clear. So I just think I don't think it's really changing anything, but giving clarification.
And Richard?
I have two thoughts, I guess, as I'm struggling with this, because I had the same sort of a puzzle that you did. One is a version of what Emmanuel, you said, that I think moving from the statutory language to non-statutory language, even if it's as seemingly trivial as any, to the, is something that one should be very careful about. And if it isn't doing anything, then I think it is safer to do the statute. But the fact that we're a little bit confused about it leads me to believe that there is something. And I tend to think you're getting at something, Greg, with the statute seems to be talking about, I'm not sure if this is right, but I think it fits with maybe what you're thinking is there's a difference between this wing of a building that is where the sanctuary and the religious activities go on, and the dormitory that's over there, and that those are different. And when you talk about any, you're talking about the two areas, and if you're talking about the, it could be read to be sort of narrowly, a more narrow area than that that's being restricted, and I don't think that that's what the statute is getting at. And I also think that that requires for folks who are determining what's in and outside the circle of permissible, that gets to be requiring a more refined, more precise, and more difficult distinction than the simple in and out. And so for those two reasons that we're sort of struggling with what they mean, but that there's at least a suggestion of a difference, and the fact that the statute is the statute, I would think strongly against changing, particularly not being able to hear or not having yet heard and not being able to think of a good argument for why that would be.
I just want to make one clarification. There's actually 3 versions of this language. The statutory language is different than our original regulatory language, which used the word any but was a little more streamlined than the statutory language. The proposal here is to change any to the. We're interested in your thoughts on all 3 versions of the language, which.
I think you can
Do you have the?
Can you put up the statutory?
It's in this comment bubble.
Oh,
so
I'm
you
sorry.
can compare them a little easier.
Got it.
And so what is the? So that's 1, 2, and the third is.
So I think what we're trying to say here is the one without the red line, without that deletion and replacement with the, is one version.
sorry, okay.
Yeah.
I gotcha.
Sorry, that was confusing. So I don't know if it helps if I read it out loud, but the statutory language says, does not involve the construction, operation, or maintenance of so much of any facility as is used or is to be used for sectarian instruction or as a place of religious worship. The original regulatory language that's in place now says involve the construction, operation, or maintenance of any part of a facility used or to be used for religious worship and sectarian instruction. The red line that we sent to propose to replace any with the. We're interested in what is the most clear to you. There wasn't meant to be a big substantive difference there. It was meant to create clarity. I don't know that it does or not, so I'm interested in what you all think the language means and what's clearer to you. And I think Haven had her card up first.
Haven had their card up first.
There, I apologize.
It's awesome. So I honestly think that both versions are clear. I do think they mean something different. So I would take the construction, operation, or maintenance of any part of a facility we use. So it would be anything that is in the building where there is in religious instruction going on. So the whole thing would be like, we're just not going to split hairs about like, is it in the lobby or is it in the sanctuary, that kind of thing. Whereas the change to construction, operation, and maintenance of the part of a facility would seem to be engaged in the splitting hairs between, is it lobby, is it sanctuary. As far as what the statutory language means to me, I feel like I can probably read that a couple different ways and I'm still puzzling it out. But I think that it more closely aligns with any rather than the.
Stephen?
Yeah, I generally agree with Richard that if the statute says one thing, we probably ought to mirror the statute as much as possible unless there's some really good reason not to. But I'm not sure what so much of any facility means on a campus like ours where, again, everything we do is infused with our religious mission. We don't have one chapel. We don't have a religious... We do have a Bible building where most of the courses taught in there are for religious instruction, but some of the courses taught in there are speech. And so I don't know if so much of any facility would include like our administrative building when every Thursday at 11 o'clock around a conference table about this size, we have a devotional time with a handful of students that want to come and participate in that. So I'm not sure if we need to be taking square footage and keeping a time log of like when are we using that administrative building for religious worship or I don't know which version gives me more freedom, but that's the one I want. So.
My 8th grade grammar teacher was sort of sitting on my shoulder here. I concur with Haven that I think the redlined version tends to. I see that as a potential narrowing, as opposed to the word any. I think that comparing the statutory version to the current regulatory version is just a cleaning up of the language. I don't see. Let's just put it this way: the difference between the current the statutory language and the current regulatory language is nothing. It doesn't mean anything. I don't think there's any real difference. I do think there's a marked difference between any and the red line version.
And just so that I'm clear, it sounds like you would prefer the original any language, or did I misunderstand?
Well, I haven't, I'd love to hear from others as to why if we have statutory language and regulatory language that are, maybe we can agree are all one and the same, what's the motivation for the change?
I just have a quick question, so maybe we can get rid of one of our three choices. Does anyone want to replace this with the statutory language? Is anyone interested in doing that? Okay, does anyone want to take the language in the bubble, the statutory language, and replace what we have in the regulations with what's in this bubble? Are any of you amenable to that? Okay.
I am not opposed to that, only because Congress is the legislative branch, and this is clearly the law, so the department is supposed to be following that. So in that vein, I am not opposed. However, sometimes a rewording to interpret the law so it is better understood is also helpful. And in that same vein, in my opinion, it seems to be clear that the law says any and not the. So those are my thoughts for now.
Boy, that made it easy. Both of Emmanuel's points get my vote. that it would be perfectly fine and appropriate to change to the statute, and that the language, the current, not the proposed change, appears to me also to do exactly the same thing and to be a perfectly appropriate thing. So I think that inclines toward not making any change, but I would certainly be perfectly fine with if the department instead put in the formal statutory language. That's okay.
So I don't like the statute, but I agree that any seems to fit it better in my reading. So given our job and some humility, that's what I'd recommend given the statute.
Can you see the bubble, or I can put up a larger version or zoom in if that's helpful.
I would also add, not that I think that we're doing this, but I think that, it is the legislative branch's role to make a substantive change. And in my opinion, saying the is a lot different than saying any. For the examples, I think that we're given, if you're in a lobby and you're doing work versus in the actual sanctuary, if you say the part of the facility, that is literally what that is talking about. So if I'm not in the sanctuary, okay, then that's not going to count for, well, then I can get paid through federal work study dollars, versus if I am in the sanctuary. That is literally what that means. So I think that the department, it's a little tricky if moving in that direction, because then I feel like you're kind of overstepping your authority in some way, arguably.
So all kinds of irrelevant comments are going through my head, so let me try to keep it relevant. I'm thinking of a recent controversy we had by us at William and Mary, where they have a chapel where they removed a historic cross that was in the chapel, so it was more open to multiple uses. But it's a chapel where they do still have some religious events, but not like they did, of course, in its founding days. So I'm wondering, with all of the non-religious uses of that chapel now, can people get work-study dollars so that it was built clearly for religious purposes? It's no longer primarily used for that. And this happens at a number of older institutions, I think. And it also reflects some of the dynamism. You mentioned speech. So we certainly, we have an ROTC event in our chapel on our campus, things like that. It's a lot of events other than just religious events, even though it was built for that as its primary purpose. And so this is just, I think, an imprecisely worded thing, but given the constraints here, I think it makes the wording a little more straightforward that we should choose for the regulation. So anyhow.
So I almost hate to say this out loud, but it sounds like we may have consensus around the original reg language with the word any in it. Do others have thoughts, or is that Andrew?
I agree.
So hooray, we have a proposal to take to the full committee.
Lynn?
Greg.
Are you saying, when you said like we kind of have a consensus around leaving it, the word any, or replacing it with the statutory?
I thought what I was hearing is that people liked the regulatory language with the word any in it as it's currently in effect. So basically we would not propose to make any change to that language.
Yeah, we would reject the red line that's in this document.
But I may have been hearing you wrong if you were wanting something different.
I thought more of a consensus was to use that paragraph that you had right out of the statutory to replace that whole sentence. Maybe I misunderstood it. I apologize then. I thought you were talking about replacing that whole sentence with right out of the.
That was one option, but there were
statutory.
three. And I can't speak for anyone else, but I don't know if I heard any really strong support for the for putting in the statutory language. But we can certainly revisit it, or we could just take a vote on any. Okay. Oh, sorry.
It's interesting because I was sort of similar ilk of Greg, that we had been talking about how important the statutory language was. So I thought that's the way that we were leaning. I personally think that the current regulatory language and the statutory language are one and the same. So to me, there's no difference versus. I think it might be more beneficial to the recommendation back to the full committee to just say that this group is recommending that the red line be rejected.
I did not mean to mischaracterize anybody, so we certainly can open this back up.
I concur with Andrew.
Can we take let's call it an explicit vote, like with some hands, just to like see the clarity? I think that might be useful just to check in where we're at, because I feel like.
You don't know what you're voting on,
Yeah.
Sure, we can do that. Shall we have 3 votes? One would be to replace this language with the statutory language. The other would be to reject the red line change, so it would be the current regulatory language with the word any in it. And the third would be to accept the red line change, changing any to the. Does that sound right?
So that sounds like three good options, but I think it would put me in a strange position. I mean, in my opinion, the current regulatory language, without any amendments, pretty much says the same thing as the statute, like it's saying the same thing. So I wouldn't see a need for it to be replaced with a statute. And I never really thought that we were voting on the statutory language. I thought it was just the regulatory language. Do we keep it as is or change it? So
What you articulated is what I was thinking. Those do seem to be where people's minds are at as the options. And I don't think that we have clarity.
Although I hate to be this person, it may be that we need some more if we're voting, we may need some more complicated, because I'm not sure whether this is what you were getting at, whether you were or you, but what I was thinking is I might well be indifferent as between the statutory language and the current regulatory language, and so I don't know how to vote if there are three options for which I have no preference as between two of them, but I clearly prefer those two over the third.
So how about if we vote on the third and maybe we can take that off the table and then there would be two options? Does that help?
rounds.
Explain that again.
So we will start with voting on the proposed change of changing any to the, and it sounds like that's coming off the table, and then we have two options and we can discuss those. Okay. Show of hands, if
Hang on a second,
you would-
Greg, you look uncomfortable
Oh.
with that.
Yeah, I'm just, and I apologize for throwing kind of a wrench in it, but to me, I like the changing of any to the, because I feel like the point of them in the statutory was to make a specific part of the facility that's used for blah blah blah. You know what I mean? Where I think any is a totally different concept. I don't think any even is the same as the statutory in my thinking. I don't take, when they say any part, I can't touch that building, any part of a building that's used for blah blah blah. Whereas I think when they're saying so much of any facility, they're narrowing down to the part of the building, whatever that building is. And again, not that you want to get into square footage, right? But I'm not comfortable leaving the word any, because I feel like that precludes, if this were one part of a massive building that also has 7 floors of academic classrooms, I don't feel like the word any allows us to do it anywhere in that facility. Whereas I feel like the part of the facility that's used, I buy into that, I get that. So I guess I assume that's why we were even looking at this, because what they're saying is, in light of all these new regulations and decisions, that we're trying to figure out, are there any of these that are a problem? And personally, I just can't agree that any part of that building, even the parts that aren't used for religious reasons, is off limits, so to speak, of work-study funding. So, I mean, that's just my thought.
So would this combine them, the part of any facility used or to be used? Would that do both or not? Okay.
No, I think that makes any function differently from how it does in the current regulation and in the statute. That makes it modify facility rather than part.
But it does say so much of any facility. It seems like the part of any facility, isn't that the same thing?
I'm sorry, say that again?
It says the regulatory language is so much of any facility. So that sounds like it's saying whatever part of any facility is used in this way.
Then the word "the" would be appropriate. The part
As
of
long as it was
facility
any
used.
facility.
Right, the part of the facility or any facility used. I don't think that's the same as saying any part of the facility.
Yeah.
Ooh, this is getting very semantic, but is it, so the word facility is in a prepositional phrase of a facility. And so is it the part that is used or to be used, or is it the facility used or to be used? Let's see. Let me find my way back to that crumb of an idea I had. So I might have to think about this one a second and reframe it. I need to find a better way to frame it.
So if the idea is if a facility is used for this purpose, then the whole thing is verboten for work study. If that's the idea, then the language doesn't make sense to me because it's so much of any facility as is used. They would just say any facility that's used. So doesn't the so much of imply the portion that has that function? Isn't that the only logical way that makes sense? Which seems to me to be logically equivalent to our regulatory language if we add any facility. So the part of any facility. But, all right, I'm really not that invested, but I'm just trying to understand it.
Sorry. No, sorry about that. I think I understand what you're saying, that, in other words, any maintenance of any part of, and then a facility that is blah, 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 or any part of a facility that is blah, 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 right? In other words, you're saying, is the statute intended to say any part of a facility that happens to be, or any part of a facility that happens to be? I think those are supposed to be the same thing, but I don't read them the same. Do you? I wasn't sure.
I apologize. I appreciate the permission of the committee. I've just got my English prof hat on. My question is, when they were drafting this, why would they not have just said maintenance of any facility used as a simpler reading? So the question is, what did they intend by saying of so much of any facility as is used? I think that's what needs to be parsed. I'm suggesting. We'll sit down.
So if we could back up for a second. So all the other issues that we've talked about up before we've gotten to this one, we've talked about case law and constitution and, what's the rationale. We haven't said any of that relative to this. And so what is, to the extent that what's the motive from the department to make this change relative to the sort of the umbrella for why we're here in the first place?
It is not being driven by case law. There was just a desire to make the language clear.
is there any evidence that there's been confusion and that this hasn't been, that this is is this a solution, is this a solution to a problem, or is this just, are there examples where there has been, that institutions have had difficulty in interpreting this?
I don't believe so.
I'm thinking of the issue of anticipating the practical impact of our regulatory language, and I don't know that we have a lot that we can do here with this, but having someone who works, say, for housekeeping as a work study, they can clean these 2 rooms but don't go in that room, and someone else has to come over and get the janitor's cart and go in there. Right? It seems very strange to me. It is cleaner to say the whole facility, but I have seen facilities where it's clearly whole other departments, the equivalent of a whole other academic building attached to the same building. And so this gets very messy. And then there are a number of religious institutions that use the equivalent of theaters for religious services, like 3 hours a week, and the entire rest of the week they're used for academic purposes. So this does get messy.
Thanks. So I was just going to say, actually, as long as Andrew invited talking about case law, there is I think a problem, but one that is in both the statute and any versions of these regulations, and that's, so if you read this as involve the construction of a facility used or to be used for religious worship or instruction. The problem with that is the or to be used makes it about the anticipated use, the plan for it, when in fact what the Supreme Court said was in looking at the constitutionality of a statute that provided for money to go to public and private, including religious colleges and universities, to build buildings, where the restriction that was written into the statute originally was that the government money can't be used for buildings that within 20 years would be put to religious uses or used for religious purposes. The Supreme Court said that's not good enough. 20 years restriction isn't good enough. You have to make sure that never in the useful life of the building is it put to religious uses, or the government money can't be used to build it. And so there is something, I just wanted to point out, there's something peculiar and I think incorrect about to be used for when it really the constitutional standard is will ever be used for, or ever within the useful life of be used for. That's a different problem than what we've been talking about, but it is a genuine problem. It's a genuine mismatch.
So, to the question of has there been a problem that this was a solution for, my example is a perfect example of it. It has been a problem for my school, because I tell the student, yes, I would love to give you this work-study job, but I can't pay you to come in and clean these bathrooms. I hate to keep using such a rude analogy, but the fact that with the word any, I have kept our students out of there, not doing not one piece of work in that building, because I don't want to run against the word any. And I see any part of the facility, and that tells me off limits. Whereas I think the word the part of a facility really does help solve that problem, because I think I should be able to use work study to come in and wax the floor or clean the restrooms or pick up trash or whatever in the part of the facility that is not used for it. I don't like eliminating the entire building because there is a part of the building that has a religious purpose to it. So that was my problem that I think changing the word to the solves.
That sounds, though, like moving from a clear rule to something that is less clear. And I think that there would be an advantage to the bright line. I understand I would like to be able to do some stuff that might be foreclosed as a motivation, but I think that as a matter of administrability, it's got to be simpler, doesn't it, to have a clear bright line in and out, and the tighter and narrower you draw the fuzzy line, the harder it is to make sense of it.
Can I respond to that real quick? I'm so sorry. I don't mean to step into your, but that's what I totally understand what you're saying, and I agree. But to me, I think the word any makes it conflict with what they're saying in the statutory. That's my thought is the word any takes away that little limitation that they put of so much of any facility. But I think they lost that when they put the word any, and I think they're getting it back when they use the word the. I feel like the word any just did away with part of the statutory, in my opinion. And I am not a legal mind, so I don't mean that in a legalistic. I'm saying in a English common sense. When they said any, to me that took out the whole statutory part of so much of any facility. But it goes back to, is it the word facility or any? So I won't.
I would like to respond and say, in my opinion, I think it's very clear what the statute says. In my opinion, of so much of any is literally saying every single aspect of that facility. I'm seeing it, in my opinion, clearly that that's what Congress intended when they used of so much of any, to be as specific of even, the corner, that none of the facility at all, none of it. So with that being said, the use of the word any, which is in current regulations, in my opinion, still mirrors congressional intent with the language. So I think I'm seeing it, on the other side of the coin with the term of so much of any.
Again, going back to hierarchy of law, Constitution, Congress, regulation, Congress certainly has the ability to attach strings to any spending statute, which this is, so they have that right. But I'm wondering if, based on Trinity Lutheran and the Justice Department memo, is this entire provision supportable constitutionally? I mean, should we completely strike Section 4 rather than quibble over the or any? Can it really be supported to forbid this government benefit on the basis of the religious use of the building?
So I guess this would be the question for the department then, is that proposal would be the statute is the statute, but Stephen has raised the question whether it is constitutionally permissible. So can the department simply decide to remove from its regulations and not enforce the statute? That doesn't sound like it's within the authority of the department to do, but I would defer to, or I would raise that question with you.
I would like to take that back to our general counsel's office. I'll try to do that this evening. And
Okay.
get back to
I mean,
you
that
tomorrow.
feels like something that would raise jurisdictional problems, but, they'll be the folks to speak to that in the first instance. That's really helpful.
So I don't have a solution, but I do have just a little note here of, you might also talk to the people at the department, whether there's any possibility of clarifying that it's used by the institution for religious worship or sectarian instruction, because often buildings are used by students just for their own meetings, and especially at public universities, it's very important that that keep open. And this is actually, I don't think Congress in any way meant to preclude public universities from letting students use their facilities. And of course, in Widmar v. Vincent, the court held that they had to. So if that might be one clarification that would be helpful, or to be used by the institution for religious worship or sectarian instruction, just to clarify, because that's actually what caused the confusion that led to Widmar.
So just to make sure that I'm clear, so I'm sorry, just to make sure that I'm clear. So you are saying that if the institution allows student groups to worship in space, that would be distinct from if the institution sponsored a religious service. Okay, perfect. Thank you.
Yeah, just because that's what happened in Widmar. What triggered Widmar was the public university there said to the student groups, there were about 100 meeting, you have to sign that you're not using the facility for religious worship or instruction. And they didn't say this is where it came from, but I'm sure it is. They were trying to be, very good public institutions. And that's what led to the whole case that then said, of course you have to let the student groups use the buildings. I'm sure we all intuit that what Congress was trying to do was not build chapels. And that's the problem, is they weren't quite explicit enough on that. So I'm with Greg, I find it very helpful that, hearing from someone who's actually having to administer this, that the proposed word change is actually clarifying and helpful to someone in your position.
Right, because, and I don't want to take your time, but as a matter of fact, because as a financial aid director, I'm responsible for the regulatory. I don't have the option of telling a program reviewer, well, I don't care because the statutory says this. They give me the regulation. That's what I'm bound to. So that's why I was trying to think that the regulation and the statutory should match in deed and thought, not necessarily that I wanted to be able to change the way I'm doing things. I just want to know what is right, so I make sure I follow that line. And I don't think those two are the same thing, in my opinion, and it makes it tough for us to follow. So I always fall on the side of that I'm going to do what the regulation tells me I have to do, because the Department of Ed is the one telling me this is how you need to process that.
I think that the common language translation of the statutory language for me would be the maintenance of any part of any facility used or to be used for religious worship. I don't think that the proposed version with the word "the" honors that. And I think that the current regulatory language using "any" could be taken to honor that, or could not be taken to honor that, depending on which lens you see it through.
I wanted to, first of all, thank Greg for providing a practitioner's perspective, because it's really important to all these contexts. The question that I would have is, the current regulation is inconvenient but understandable, and what you're proposing is to exchange inconvenient and understandable for something that is flexible. And I'm not so sure that I'm willing to make that trade-off, because I think when you add in the flexibility, you open it up to more subjective interpretation.
Thank you, and I appreciate that. I understand what you're saying. And again, my thought was not to make it more flexible so that we could or couldn't do this or that. My thought was, if the statutory really meant to say any part of this whole facility, they would have said any part of the facility. They didn't. They said of so much of any facility. Why did they add the so much if they weren't trying to really be specific? Because it does make sense that we shouldn't use federal funds to take care of the middle of the chapel where the actual religious ceremony goes in. But people also stop in and use the restrooms, as a passing by. So my point was just that I don't think they would have made it so wordy in the statutory if they literally meant any part of the building is off limits. That was my point. Thank you.
I don't know. I tend to think that so much of any trying to put myself into the shoes of a legislator, I think that they were trying to use language that was more restrictive when you're maybe reading it as language that's less restrictive. I think that that's, at least in sort of my experience in how folks think about statutory and regulatory drafting, that feels like the language you put in to say, whether it's good grammatically or not, we're going to make really clear what we're saying, so we throw in these extra words and as a way to emphasize that. That's what it looks like to me. Just because I've seen that in so many different contexts of, we put in so much because we want to make it really clear that we're saying so much of, as every square inch of, or something like that. That was the congressional intent there. Do with that what you will, but that's certainly how it feels to me.
So now we have about half an hour left. I suggest that I have a few things I want to talk about in wrapping up, and why don't we do that to make sure we get that in, and if there's time we can go back and look at the Gear Up language. So the first thing I wanted to do is to flag the provisions that we have not talked about yet. The first is there's the Gear Up section on page 5 of the red lines that you have. I also wanted to flag a couple things that you got by email or in your folder, but you may not have focused on. And the first is the red line of Part 600, which is a pretty thick document. On page 7 of that document, so this would be in your folder, Part 600. Yes. So Part 600, page 7, at the top of the page, there is a definition of religious mission, and I think this group should be discussing that, even though it's part of the accreditation work. So I wanted to flag that for everybody so that you had a chance to look at it tonight if you haven't already. Also in section 602, which is another thick red line, and where is mine? Okay, in 602, the red line on page 14 and 15, there is some language relating to the religious mission in the context of accreditation. And I thought this committee should also be looking at that. So that is Part 602 in the red lines, page 14, the bottom of page 14, and through the middle, maybe the top 2/3 of page 15. So it's section 602.18. Yeah.
To help me think about, I had one really niggling question about what it meant under the heading of 602.18. If I can ask, it'll help me think about it for tomorrow.
Sure.
Where it says the agency must consistently apply and enforce. Do we know whether agency there means the department or the accrediting entity?
Accrediting agencies.
Thank you.
Okay, so does everybody have those two sections and understand what we're going to talk about tomorrow?
Can you repeat the second one? I got the
Absolutely.
first one, but I got lost in my papers.
So in Part 602, in the red line, should be a pretty thick document. On page 14 at the bottom, section 602.18. And that goes on into the next page. So I think we should look at that whole section.
And I'm sorry, what was the first one?
The first one, absolutely. The first one is part 600. And in the red line on page 7, at the top, this is the definition section, and this is the definition of religious mission, which is at the top of page 7. It's one paragraph that's fairly short. Okay, and then we had a request from Richard to take a look at 609 on state authorization and 611. And I'm going to pass those around to everybody so that you have them. And Richard, if tomorrow you can raise the concerns you have with those, that would be great. And then we have a couple of things that we will go back and look at this evening. One is we heard that you'd like a list of the volunteer service that's been approved. My guess is that we are not going to have such a list because the servicers for the different servicers would be approving those. So I'm not sure that we get a central list at the department. We will check and see, and I will share it if we do have such a list. We have also said that we would go back to OGC and ask for interpretation of the any language and whether the whole thing can be stricken and whether it's unconstitutional. We will also ask about the distinction between whether students are using the facility for religious worship or whether the institution is. Is there anything else that people feel like is outstanding either on our behalf or things that you raised that... Yes, Stephen.
While you're going to the Office of General Counsel, maybe just ask the question if the clause "or to be used for religious worship" refers back to the construction portion, that funds can't be used to construct a facility that's intended to be used for religious worship, or if there's some other meaning there.
Yes, I will do that. Thank you. So another thing I wanted to raise, oh, I'm sorry, Richard, did you? Okay. Another thing I wanted to raise, some of you are from this area and some of you are from farther north and you don't know how we handle snow. Unfortunately, we have snow predicted for tonight and Washington closes down in the snow. When we get snow, we are often 1 or 2 hours delayed. We are going to follow whatever the federal government does. You can look on the Office of Personnel Management, so opm.gov's website, and they will announce whether the federal government is closed. It's also announced on most every TV station, radio station that's local. So you should be able to find out pretty easily. If we are delayed 1 hour, we will come at 10 rather than at 9. If we are delayed 2 hours, we will come at 11 rather than 9. In the event that the government is closed, we do not have access to this building, and tomorrow would be canceled. I hope that won't happen, and we already had that happen on Monday. But one other thing I want to mention is sometimes they will say that people can telework or take leave without approval. The government is open in that case, and we would come here. We will all be here and set up, ready to go. So it's just if we are delayed, and then whatever number of hours we are delayed from 9 o'clock is when we would start. If we are closed, we're closed. Anything else, we're open and here. Greg.
So using that example, let's say they say it's a 2-hour delay, so we're going to start at 11. Does that mean we're going to go until 7? or do we still leave it? I'm just making plans for going home.
No, I
and
know
I want to
that-
make sure
that-
that I don't leave.
Many of you have travel plans. We
Okay.
are not going to keep you here till 7.
So it's not
we
getting
will
into added
leave
to
by-
the end of
by
it.
5 o'clock.
I just want to be honest.
Yeah. So we have 2 other days scheduled in February. So if we lose a couple hours, we'll just have to make it up in those days. We will not keep people late. You can keep your flights as they are.
Not about the weather, but did I understand the schedule that, so the full committee and subcommittees meet in February, the full committee only meets in March, or whatever or is that incorrect?
That is incorrect. The next subcommittee meeting is, I believe, it's February 12th and 13th. I don't know whether you, I believe it's the February 12th and 13th. So we will have 2 more days before the full committee meets. The full committee meets the 19th through the 22nd of February. So we would report back to them at that point. Then we meet again in March, and I can't remember the dates, for 2 days. And then the final full committee meeting is towards the end of March.
Thanks. That's what I had thought from what we originally saw, and I think I misunderstood something that you said this morning.
Oh, okay.
I
may not have
got
been
something
clear.
twisted up. Thank you.
Okay.
If tomorrow was canceled, what would you report back?
We have 2 more days in February, so this group would reconvene before the full committee meets. So nothing would be reported back in any event, whether we're here tomorrow or not. And I hope that we will be here. I just didn't want people to be confused, particularly some of you from climates where when we get 2 inches of snow, you're going to laugh at us that we're 2 hours late. It wouldn't occur to you that everything would be canceled. Yes, our Rhode Island person, I don't know if you've been in D.C. in the snow, but it's
It's not a pretty picture.
no, it's not our glorious moment.
Is it too much maybe to ask if Ashley or someone could just drop us an email letting us know if it's canceled? I don't know those sites you're talking about to look at to see.
Sure. I
Like
think
this time they
that,
sent us notes ahead of time saying it was canceled for these days.
Yes. So Aaron Washington sends something to the whole list that includes the committee members, the subcommittee members. So you should get an email that way. If you are staying across the street, you'll notice that there will not be many people here in the morning. This is almost all federal buildings around here, so it will be very quiet at 9 in the morning if we're 2 hours late. Okay, any questions about snow? Just make sure there's nothing else. And I guess another thing for everybody to sleep on is to think about how we want to present recommendations to the committee, whether we want to have multiple options, whether we would have one or more spokesperson, and who that would be is another thing to give some thought to. Okay. Any logistical questions or thoughts? Yes.
Just one very quickly. You said we meet one more time. We have March dates too, right?
Sure. So it might be helpful just to know that on our on Ed's webpage, I can send the link to all of you later if that's helpful. But we do have the dates and locations for where all the sessions will be, including our subcommittee, the other subcommittees, and the main committee, as well as links to the live streams.
And could you read out loud? Some people might have trouble reading the board.
Sure.
The dates coming up.
Sure. So the future dates are February 12th through 13th, and it will be in this room again. And then the third session will be March 11th and 12th, and that'll be on the first floor. So there'll be a little bit, it'll be a little bit easier to move around in the building for that last session.
And we are looking to see whether there's another option other than this room. I realize this is tight and it was warm. So it will absolutely be in this building. If you get here and we're in another room, it's because it's bigger and we'll give you a little more elbow room. Do you have the dates for the full committee meetings too?
Yeah, they're they're on the same page. So if we just go distances, yes. So yeah, the main committee meets next on February 19th through the 22nd, and that's actually going to be not in this building. It's going to be in PCP, and there will be a live stream for that as well. And then session 3 is the 25th through the 28th, so we'll be meeting before those committees to make recommendations. And that one will, again, be in this building.
PCP is the one by the Mandarin and all that stuff, is that right?
Yes.
Microphone, please.
Yes. I was looking back at my notes, and I think, but am not sure, that that somebody had asked about the department providing information on, what research, what details on the eligibility of members of religious orders for student aid and how that actually happens. The history and whatever went into that, and also the sort of practice of it. Maybe I misunderstood something, but I think there was going to be some attempt to see what could be found on that.
I'm sorry, could you repeat that one more time?
I'm not sure I can. I think it was, I think it was in part about the history and the original context of the provisions about eligibility of members of religious orders for student aid, and then something too on the what that actually looks like in practice. I mean, it's possible that I added the last piece because maybe that was in my head, but I at least think I remembered the former.
So
I don't remember.
We
who
did
asked for it,
provide what we have, which was the oldest reference we could find. I believe it was 1974.
Okay.
Our general counsel's office is also looking to see if there's any more context. If there is, we will bring that as well. But the main response, I think, we've given to you. How it works in practice, I will go back and see what information we have on that. We may not, because it happens on college campuses across the country, and so we may not. I don't know. I will see what we have.
Thanks.
Sure. Any other comments, questions? Okay. So we now have 20 minutes. Do you want to start on the gear up, or are you tired and would like to come back tomorrow? I see one vote for coming back tomorrow.
Once again, I concur with Andrew.
Okay.
And since he's the expert or one of them on this issue, well rested would be good.
I would prefer to have a night's sleep to process all this before we start on Gear Up tomorrow.
If
it would please the rest of the committee.
We'll be geared up.
Yes, I hope everybody. I hope everybody has a good evening, and hopefully we will be back here at 9 tomorrow morning. Thank you all.
Thank you for the cookies.
Yes, thank you.